Consent is actually very important. Forget that I said that. Do not quote me on that. Beep boop, we have started the recording, and this is the recording for Chapter 16, Lesson 1's lecture, talking about rights of the accused before trial. Right before we started this recording, I misspoke and referred to this as rights that Americans have before trial. But like we know about the 14th Amendment, it promises due process to anyone that is subject to American law, not just American citizens. What I want to talk about today are Amendments 4, 5, and 6, going along with some of the reading with Chapter 16, Lesson 1, although 4, 5, and 6 all impact during trial rights as well, especially number 6. But talk a little bit about some of the rights that, that exist prior to a trial for those who have been criminally accused. Let's start off with the scope of number 4, or Amendment number 4, the right of people to be secure in their possessions and papers and personal effects, generally seen when dealing with the criminally accused as the protection against warrantless searches. Warrantless not only means what that word means outside of a government context of without valid reason or without a good cause, but it also means without a actual physical document that is a search warrant in this case. Search of private property by police officers can only occur in one of the 3 following circumstances. Number 1, if there's been a valid arrest that has been made. Number 2, if the owner has consented to it. Or number 3, if there is a court-issued warrant specifying what it is to be searched and what is being searched for. Probably one of our biggest and most important cases there is the 1961 case of Mapp versus Ohio. In your textbook, Mapp versus Ohio is credited as creating the exclusionary rule, the idea that any evidence that is collected outside of the scope of what a search warrant would normally allow is not to be admitted in court. Yep, that's a big legacy of Mapp versus Ohio, but wait, there's more. Mapp versus Ohio is also the case that incorporates search warrant rights to these states. One of the things that the police of Ohio said in that case was, well, wait a second, search warrants, that's a national government thing, that isn't an Ohio thing. And the court ruled that no, search warrants are a fundamental part, a fundamental liberty associated with the Bill of Rights, and therefore apply to state governments as well. Another important part of Mapp versus Ohio is that a search warrant must specify exactly what's to be searched and what is to be searched for. The case of Mapp versus Ohio is an interesting and salacious one. Miss Mapp was a woman who ran a house for people engaging in the world's oldest profession. I think I can say that and we can understand the meaning without, needing to demonetize our video for salacious content. This Mapp was running a house of ill repute, and it was known to be sort of a house of ill repute when the police officers came knocking on the door, demanding to search the premise for somebody connected to a set of bomb threats. Well, Miss Mapp rightly says, okay, there might be a lot of wrong things going on here, but bomb threats are not one of them, and you have no reason to believe that bomb threats are one of them. The police present a blank sheet of paper and say, well, but we have a search warrant. One of the rules here, kids, a blank sheet of paper is not a search warrant. Miss Mapp confiscates the blank sheet of paper from the police that they had claimed was a warrant, and the police conduct the search of the house anyway. Over the course of the search of the house, they found all sorts of things that were against Ohio state law. But importantly, they did not find any bombing suspects or evidence of bomb threats. All evidence the police find, first of all, since they didn't have a real warrant at all, and second of all, even if they did have a real warrant, it would have limited them to search for evidence in connection to bombing. All evidence that the police found was ruled to be inadmissible in court in that Mapp versus Ohio case. So Mapp is an important case for us to understanding search warrants in general. Yes, search warrants apply at all levels of government. Anything that's found outside of a search warrant, be that because there wasn't a search warrant issued, or because it's outside of the scope of what the search warrant called for, is then inadmissible at the court level. The police might still make a wrongful arrest, but that arrest will not be upheld, and a conviction will not be upheld by a court because of wrongful evidence, because a jury will not be able to use that wrongful evidence, and the prosecution will not be able to insert that wrongful evidence in front of a jury. Taking a look here at the other things that occur, or other times when search and seizure can occur, one of the ones that most often complicates cases, and if we think all the way back to when we were doing newspaper theater as a form of talking about police rights and search rights, is the consent of the owner. A lot of the cases that we dealt with when we dealt with newspaper theater, cases like Hine versus North Carolina, came down to a case where, well, the police were performing what was probably an illegal search, but the person who was in that position at some point said, sure, you can search, at which point the question of search warrants goes out the window if the person consents to the search. Have I told you in class my story about my illegal police search that I consented to when I was working at the Virginia Beach oceanfront? Dead silence, so I will tell it quickly. When I was renting bikes at the Virginia Beach oceanfront, the police came up to me one day and asked if they could search my backpack. I was a little inquisitive and a little defensive, so I asked them why. And one police officer said to me, well, because someone matching your description has stolen my partner's gun. And I looked, and sure enough, one of these two police officers had had their gun stolen from their waist holster, which shouldn't be a thing that's possible, but having not stolen a police officer's gun at any point in my life, I did allow them to search my backpack, which had, comic books and a sandwich in it. If I wanted to, could I have denied that search? Absolutely. I could have said, you need to come back with a warrant. But in the moment, I did decide to consent to that search. Had they found anything incriminating, which there wasn't in my backpack, so I wasn't worried about that, but had they found anything incriminating, that would have been valid evidence because I consented to that search. This also did give me enough time to think that someone matching my description, which was at that time, a 17-year-old asthmatic boy, had stolen that officer's gun, and that police officer was just having a bad day. Searches are also valid instantly upon any sort of valid arrest. If one is being arrested for a crime such as abuse, assault, disturbing the peace, then that person can be searched. Not only can that person be searched, but anything that is under that person's immediate control is immediately available to search for the police. This was mentioned as an exception in our textbook of things that are in plain view or things that could be potentially dangerous to an officer's safety, and that's why those searches are permissible. The other part of search is seizure. When can the government take private property, and when can the government seize private property? According to the Fifth and 14th Amendments, the private property of citizens cannot be taken unless there is a due process. If you go through a legal court process and the courts determine that this property can be seized, then that property can be seized. Or with just compensation if that property is being put to public use. That goes back to something we talked about at the beginning of the year when we were talking about the Bill of Rights and when we were talking about eminent domain. The idea that the government can, let's say, forcibly purchase your land if they're building an airport there, or forcibly purchase your house if they are building a highway that goes through that. We wouldn't be able to have railroads and highways and airports if it weren't for eminent domain power, because then somebody would reasonably hold up the government for an extortionate price. One controversy that exists here, and if you like to keep yourself informed of hot button current issues with police and civil rights, is that of civil asset forfeiture. John Oliver did a very good video about this a couple of years ago, but the idea of civil asset forfeiture is that if something is being used as evidence in a police arrest, then the police may hold on to that private property as evidence. Well, if the police even wrongfully arrest somebody who is carrying a large amount of cash or carrying expensive weapons or driving a vehicle, the question of can the police seize that as evidence and what is done if the police abuse that power has become an ongoing controversy in law enforcement. It's not one that we'll talk too much about or ever quiz on, but it is a interesting topic to keep yourself informed of. The other important part of last night's reading are one's rights against self-incrimination, or as we commonly think of that protection within the Fifth Amendment, the right to remain silent, because that's often how it's phrased in the Miranda warning. I did, you might notice, italicized warning there. Sometimes we see the Miranda warning referred to as Miranda rights. It's worth noting that the case of Miranda versus Arizona did nothing to expand the rights of the criminally accused. And by definition, the Miranda rights are not new rights. What it is it's a warning to people who are being put under arrest of the rights that they already had. It is letting them know what their constitutional protections are. In the 1966 case of Miranda versus Arizona, which was a rape case, the suspect claimed that, well, he did not know what his rights were and was put at a legal disadvantage and therefore being treated unequally under the laws because he did not know what his legal protections were. The ruling that the court came with out of that was that, well, anyone who is being arrested must be briefly informed by the police of their rights at the time of their arrest. We know this as the law and order warning. You have the right to remain silent, you have the right to an attorney, those things that we listed as we were taking our reading check. Something to know about the Miranda warning, though, is that those rights exist even without the warning being issued, and they exist even without there being an arrest that occurs. This was mentioned in our text briefly by the case of Escobedo versus Illinois, but in the case of Escobedo versus Illinois, the police were trying to get around the suspect's right to an attorney. The suspect was asking for an attorney, the suspect was saying that they were not going to speak without an attorney, and the police said, oh no, you only get an attorney if you've been arrested. We're just holding you here for questioning. We haven't issued an arrest yet. You get your attorney once you've been arrested. So go ahead and start talking, or else we might arrest you. No, one has a right to an attorney at any point that they might be under questioning, at any point where they might be a suspect, even if they're not a suspect and they are being questioned by the police, one has a right to legal representation. The Fifth Amendment has a bit of a dirty name from Law and Order, though, because when we watch Law and Order, the Fifth Amendment and somebody pleading the Fifth, that's how you know that they're guilty. And we oftentimes assume that the Fifth Amendment it only exists to conceal guilt. It's worth noting that the Supreme Court disagrees. The Supreme Court has ruled that the Fifth Amendment can also be used equally to protect the innocent, and that the innocent have an equal right to not accidentally or wrongfully incriminate themselves. The case that this comes from is one that I think is very hopefully not relatable to high schoolers, but really strikes home to high schoolers the reason why this is an important protection. The tragic 2001 case of Ohio versus Reiner. The Ohio versus Reiner case in 2001 was a case of wrongful death with an infant. The infant died of what appeared to be shaken baby syndrome or of some sort of physical trauma. The father of the infant, who was the one who was being charged with the crime, wanted to say, well, I'm not the only one who's ever with the infant. There's also this babysitter that we hire. And sure, we've hired this babysitter in the past. I don't know when the last time is that we hired her, but maybe she did it. I don't know. And tried to accuse a babysitter of being the one who caused the wrongful death of the infant. The babysitter, rightfully so, said, I'm not going to speak to anyone about my time babysitting that child. I'm not going to, the father can't put me there within the right time frame. No one can prove that I was a babysitter. Why would I put myself in danger by saying, oh, here are all of the times that I handled that child when it can't be proven? And the prosecution tried to say, well, the Fifth Amendment only protects those who are not admitting guilt. You are, by your own admission, innocent. But it was ruled that this babysitter was allowed to completely refuse to comply with requests for when she had been there, how she had handled that child, because no one was able to provide evidence against her. She was importantly innocent, but also I think that for teenagers who are in a profession or teenagers who are sometimes in the profession where they are babysitting, that's a terrifying concept that they could be accused of a heinous crime without any evidence that they had been there. You want to have the Fifth Amendment to be able to secure you at that time and saying, nope, I'm not entering evidence against myself. You have to find evidence against me. The Fifth Amendment is incredibly important then because it protects one from being wrongfully quoted by the police. If one has entered testimony with the police, well, then the police get to define what that testimony was. If you are wrongfully quoted by the police, well, then if you have spoken to the police, you can be wrongfully quoted. Therefore, it is important that one invokes their Fifth Amendment right to remain silent. If one speaks to the police without a lawyer present, they might confess to crimes that they are unaware of. I've done this plenty of times with my classes before. I have asked them for a show of hands of who it is that is a gardener who might like to have some hyacinth plants from South Carolina that I had just too many of to deal with. And I always get like one gullible child who raises their hand, and I'm like, aha, you just committed a crime because agreeing to smuggle hyacinth across state borders is a federal crime. You don't even have to do it. You don't even have to have the hyacinth present. You just have to agree to be able to do it. And this is a reason why you always want to have your lawyer present if you're talking to the police. All sorts of reasons why the Fifth Amendment is important, even to those who are innocent and have theoretically nothing to conceal. If you are of the belief that the Fifth Amendment is not important, I would encourage you to watch the video I link to in this slide here. It is a Regents University Law School lecture being given by Professor James Duane a number of years ago, but it went viral on the internet because he is energetic and passionate about this. His 25 minutes part of that lecture is very good. It's the best summary of why the Fifth Amendment is a fundamental protection, and he makes it entertaining. It's voluntary watching. I usually have students watch it on a day with a substitute teacher, but it is certainly worth watching and something I've seen countless times and still always appreciate. Those are some of the rights that exist in the United States prior to a case going to trial. Next section, we'll talk about cases when they do go to trial, and later on we will talk about rights for the criminally convicted. But that's what we've got for today. In just a little bit, I will stop the lecture. We will take any, or stop the recording. We will take any questions, and we'll say goodbye to Emily. And stop recording.